All right. I think we're about ready to start. All good things come to a start. I will say, it seems like you all have been around here a bit, maybe, but for any newcomers, this is how we start things. This used to be called Human Rights Happy Hour, and part of the idea was to have a chance and see other folks who you might want to talk to, and so I'm glad that you all took advantage of that. My name is Karen Engel, and I teach at the law school, and I co-direct with Neville Hode here, the Rapoport Center for Human Rights and Justice. Welcome to the first event in a semester-long colloquium on reproductive justice, criminal law, and the carceral state. Before we begin, I'd like to acknowledge that we're meeting on the indigenous lands of Turtle Island, and I'd like to acknowledge, in addition, the Alabama Coushatta, Caddo, Carrizo, Comacrudo, Coeltecan, Comanche, Kickapoo, Lipan Apache, Tonkawa, and Isleta del Sur Pueblo, and all the American Indian and indigenous peoples and communities who have been on or have become a part of these lands and territories in Texas. So this colloquium is part of the Rapoport Center's relatively new Sissy Farenthold Reproductive Justice Defense Project. Blake Rocap is the director of the project. And it's also a part of a seminar that I'm teaching at the law school, which has students from law, LBJ, and social work. And so I think mostly these two tables are the students. And I realize at some point you all might want to talk to other people during the happy hour portion, but thank you for sticking together today. And I thought that would be helpful for our speakers as well, because they've written papers about the draft that Rachel Rebouché will present today, and we've discussed her work in class for a couple of hours. So when we go to the question and answer period, they'll have the chance to ask the first couple of questions, and then don't worry, we have a lot of time, and we will open it up to everyone. So with that, it's my enormous pleasure and honor to introduce Rachel Rebouché and to have her here. She's sitting right here. You'll see more of her in a moment. She is Dean and James E. Beasley Professor of Law at Temple University Beasley School of Law. And she is somehow managing to be dean, and write an amazing amount of scholarship at the same time, which is a skill that few people have. And I really appreciate that she's taken the time, especially at the beginning of the semester, to ignore Temple Law School and come be with us today, if just ignore them for a couple of hours. Do I need to take your phone? So there's so much that I could say about Rachel, but I could talk about her scholarship for hours, but I'm actually just going to tell you a little bit about what she's been doing in the last couple of years, and maybe even the last year. So she is a leading scholar in reproductive health law and family law, and actually, to go back a few years, I will just say, before she was an academic, she has a very rich background in advocacy on issues of reproductive rights in many places, including the United States, Ireland, and South Africa. Even before Dobbs was handed down, although not that too much before, Rachel was hard at work with her co-authors David Cohen and Greer Donnelly to understand the legal landscape of a post-Roe world. And she's published scholarly articles in the Columbia and Stanford Law Reviews on that, as well as op-eds in the New York Times and other places. My favorite sort of media outlet appearance that Rachel has made was on Samantha Bee, who I think flew her to, was it Yellowstone National Park, to talk about federal enclaves. And so that's to say that Rachel has a sense of humor as well. Not about the federal enclaves, but about Samantha Bee. So also Rachel's from Texas. And not only has she been involved in a number of projects at the law school and the Rapoport Center with us in the past, but she is actually in many ways responsible for the Sissy Farenthold Reproductive Justice Defense Project. So some of you might have seen some webinars that we did right after Dobbs. If you didn't, I commend them to you. They're still on the Rapoport Center website. But Rachel was really instrumental in making those happen, and then was an active participant in both of them. And those discussions, which were what do we do in Texas after Dobbs now, ended up being the beginning of this project and our real sense with the input of a lot of people that we needed to be thinking at the intersection of reproductive rights and criminal law, which is still a relatively new space, and that we needed to do it through a reproductive justice lens. So it's only fitting that Rachel kick off this series for us, and with her talk on reproductive justice and abortion pills, which is partly based on a forthcoming article in the Stanford Law Review. And I understand that if we really push, we can still she can still make changes to it. So she's very much looking forward to the feedback. After Rachel speaks, we'll have the opportunity to hear a response from Carrie White, who is sitting over here. Carrie is Associate Professor of Sociology and Social Work here at UT, and is also the lead investigator with the Texas Policy Evaluation Project. Carrie has a very long list of publications and rich work in a variety of areas, but most importantly for this, and most recently, which is a long period of time, studying and presenting the lived experiences of women seeking access to reproductive health care in Texas and in other places. And I think Carrie and Rachel have actually written an article together, so that's cool too. So with no further ado, please join me in welcoming Rachel Rebouché.
Thank you. I never thought that writing about abortion would be my hobby, not my day job, but it turns out my day job's a little bit different than writing about abortion these days. But I'm really delighted to be here. First of all, I want to thank the students who I met some of you over lunch. Thank you for your response papers, for the amazing graphic retelling of the article that you created, and just for your interest. I really appreciate your time and your investment in the draft. And I want to thank Carolyn Hahn, who made all the arrangements for my travel here. Thank you to Carolyn. Carrie White, who I'm delighted to have comment on this paper. I've admired Carrie's work for so many years, and I'm not saying that just because we're co-authors, but I'm really pleased and so thrilled that that I get to hear your thoughts on this draft. And finally, of course, Karen Engel, who has been a great friend and a great mentor for more years than I can count, and as I told her students today, was probably one of the most important people in helping me decide to become a legal academic, because Karen, I think, models the kind of legal academic that I'd like to be. So thank you, Karen. All right, so since Dobbs, the decision last year that we all know very well, just to provide some background, over a third of the states in the country now outlaw abortion from the earliest moments of pregnancy. Several of those states enforce near total abortion bans. We're in one. And some of those other states would enforce bans but for court injunctions. At the same time, many of you know that over a dozen states had enacted constitutional measures, passed statutes that protect abortion rights, particularly through the first trimester, and then often with exceptions in the second and third trimesters. At the same time, over the last year and a half, 17 states have passed what have been called shield laws that seek to protect providers and people seeking protected reproductive health care from out-of-state lawsuits and criminal investigations. I'll describe that a little bit more in detail in a moment. So these aren't just prophylactic measures. The emerging legal landscape is punctuated with conflict, particularly as states seek to impose their policy choices as widely as possible, even across state lines. So take Idaho's abortion trafficking law that's recently been passed and applies to minors. It penalizes people who assist minors once they come back to Idaho or as they try to leave Idaho when they are seeking an abortion out of state. You might know this well because cities in Texas like Odessa have passed similar measures, and there has been a concerted campaign for other cities to pass abortion trafficking ordinances that apply to everyone, not just minors. recently as well, the Alabama Attorney General argued in a court filing that the state has the authority to bring conspiracy charges against groups who have helped people travel to another state for an abortion. So there are, to be sure, constitutional arguments that could challenge such laws, but those arguments are largely untested and underdeveloped. Conflict is interjurisdictional too. The current federal government has made strides, has taken important steps to try to protect abortion rights. But I give you that background for those who may be not as familiar with the legal landscape after Dobbs, not just to talk about abortion law and how it's changed. To be sure, it's changed quite a lot. I want to talk today about the change in abortion practice. I want to focus on medication abortion and what the regulation and uptake of abortion pills might mean for the reproductive justice movement. That's the subject of the article that Karen mentioned that I've co-authored with my two wonderful colleagues, David Cohen and Greer Donnelly. It has the very subtle name, that paper, of abortion pills, in case you were curious about what the paper addresses. So by way of background, medication abortion is the two-drug regimen that ends pregnancy before 10 to 12 weeks of gestation. The growth of virtual clinics which offer medication abortion through telehealth followed a court order in 2020 that temporarily enjoined the FDA's restriction on the first drug of a medication abortion, mifepristone. Of the 20,000 drugs regulated by the agency and the 16 with the same restrictions as mifepristone, mifepristone was the only one that patients had to retrieve at a healthcare facility but could take without provider presence. So in December 2021, the FDA announced that it would lift that rule, an action that has been subject to litigation before the Fifth Circuit, something I'll mention in a little bit more detail in a moment. With the removal of the in-person restriction, mifepristone, along with the second drug, misoprostol, can now be mailed to patients as prescribed by a certified provider. And as of January of this year, pharmacies that seek certification will be allowed to dispense the drug as well. Virtual abortion clinics are growing in number. So for context, you can think about the example of abortion on demand. The first large-scale telehealth abortion service, entirely virtual, run by a US-based provider. So how does it work? An automated asynchronous intake is followed by an informed consent process using a pre-recorded video. Gestational age is assessed by a home pregnancy test, and the date of the first day of the last menstrual period. Abortion on demand, or AOD, prescribes medication up through 10 weeks, which is what the FDA approves. 12-week prescription off-label is also common, and only for people 18 or older in order to involve parental involvement restrictions. A nod to Carrie, because our work involved parental involvement restrictions. The platform used by AOD was built with telehealth regulations in mind, as well as HIPAA, and the process is the same for the 22 states in which AOD operates. The entire process, from start to finish, counseling to receipt of the pills, takes between 2 to 4 days. It is $300 less than an medication abortion that you would receive in a clinic, and it is increasingly the model that virtual clinics have adopted, though others have gone to 12 weeks, 13 weeks of gestation, have had a sliding scale for payment. In addition to virtual clinics like AOD, which deliver telehealth, Aid Access is a group that works with providers to mail medication abortion across the country, including states where abortion or teleabortion is prohibited. Plan C has been important to that endeavor, a leading nonprofit that provides information about how to gain access to services like AOD and Aid Access. In addition, people buy pills online without the assistance of Aid Access and without provider oversight. They use mail forwarding, instructions readily available on social media sites to use telehealth services outside their states. So I tell you this background to set the stage for how abortion care has shifted dramatically in the use of mailed medication abortion. But there are some caveats that are worth mentioning and emphasizing before we go on to how that has been attacked, with criminal law being the instrument for those strategies. For one, teleabortion depends on various forms of privilege, utilizing a smartphone, having a stable internet connection, or having an uncomplicated pregnancy, which, because of US health disparities, we know is more likely the case for wealthier and white people. For another, even with remote care, the need for clinical spaces for abortion past 10, 12, 13 weeks, or when a patient is not a candidate for telehealth, will not disappear. Remote care cannot assist those who need or prefer aspiration abortion, or in the rarer case, surgical abortion. Nevertheless, mailed medication abortion, because of its design and based on how it is implemented, is now a vehicle for delivering care across state lines, no matter where you live. That reality presents an existential crisis for the anti-abortion movement. There are numerous strategies at the moment to shut down mail medication abortion, and because there is a lot happening in this space, I want to focus on just a few that I think are relevant to Karen's seminar. The first, the Comstock Act, and the second, strategies to surveil and prosecute providers and patients. So what's the Comstock Act, and why are we going to talk about it briefly? Alliance for Hippocratic Medicine sued to remove mifepristone from the market by claiming that it was unlawful for the FDA to approve the drug in the first place, 23 years ago. Judge Kosmarek and Amarillo, district court judge, agreed. In April 2023, for those in the room that may not be familiar, the district court issued a preliminary injunction suspending mifepristone's approval. On emergency appeal, the Fifth Circuit stayed the district court's suspension of the mifepristone approval, but affirmed the injunction suspension of all FDA action starting and after 2016, including the 2021-2022 lift of the in-person pickup requirement. Before the injunction could take effect, the Supreme Court stayed the order until final disposition, whether denial of cert, on appeal from the Fifth Circuit. Cert was filed just last week by Danco, the name brand manufacturer of mifepristone, or a final decision on the merits if cert is granted. Last month, the Fifth Circuit ruled that the plaintiffs likely failed to timely challenge the 2000 approval of mifepristone and likely failed to plead an injury with regard to mifepristone's generic approval in 2019. However, the circuit found that the agency's subsequent changes to the mifepristone label and to the restrictions imposed on it, the REMS, including its 2021 decision, were likely arbitrary and capricious under administrative law and thus unlawful. Though the circuit decision will have no immediate effect, if the pre-2016 restrictions were to go in effect, the consequences could be significant. For the sake of time, I can answer questions about the Fifth Circuit ruling if there's interest and their impact. There's clearly experts in this room who could do the same. Hat tip to Professor Liz Sepper, who is sitting in the back. But for now, I want to focus on the litigation's reliance on a 150-year-old federal law, the Comstock Act, which could threaten the legality of mailing abortion pills anywhere. So the act's named after Anthony Comstock. It's a 19th century anti-vice and obscenity crusader. Made quite a name for himself. The law dates back to 1873. It prohibited importation and mailing of information regarding, quote, how or by what means conception may be prevented or abortion produced. In 1876, the law was updated to clarify that the obscene material covered by the act was non-mailable matter and shall not be conveyed in the mails or delivered from any post office or any letter carrier. And then in 1909, still more clarification that mailing included express mail services and common characters. Now, it's just worth pausing that this 150-year-old statute, how it defines the non-mailable matter. Every article or thing designed, adapted, or intended for producing abortion, every article, instrument, substance, drug, medicine, or thing which is advertised or described in a manner calculated to lead another to use or apply it for producing an abortion. So for the first 40 years of the Comstock Act, Anthony Comstock would have been proud. It was successfully enforced. He bragged that over 3,000 people, 3,500 people were convicted under the law, over 160 tons of literature destroyed. Fun fact, Anthony Comstock was known to solicit obscene material, and then when it was mailed to him, prosecute the person who mailed it to him. He sounds like a fun guy. So here's the problem. Providers, abortion rights activists, organizations, pharmacies, drug manufacturers, they've ignored the Comstock Act until this point. There are good reasons to. It's been in disuse for over 100 years. It hadn't been enforced. Courts in the 1930s had looked at the Comstock law broadly and decided it only applied in narrow circumstances. But the plain language of the act is so broad that it could cover almost every medical instrument, supply, or drug that could possibly be used for any abortion. In other words, absent the narrowing construction applied by the federal circuit courts, the act could effectively ban all abortion services nationwide, because every pill or instrument or article or thing that goes through the mail that touches abortion could be swept up in this law that has been in disuse. And there are no exceptions under the Comstock Act. There's no exception explicit in its language for life or health or anything else in the ban that it would create. But after 100 years of non-enforcement, Comstock lives, at least for some members of the Fifth Circuit and Judge Kaczmarek, because the argument summed up very briefly and not able to do it justice in the time we have, the FDA could not have lifted the in-person pickup rule because the Comstock Act prohibits and punishes mailed abortion pills. So penalizing anything mailed at the federal level through federal criminal law complements efforts to target information about medication abortion as well as its manufacturing and distribution chains. Legislators in Texas, for example, have floated the idea of requiring internet providers to block abortion pill websites, though it is unclear if that's constitutional, and it's unclear how this would work in practice. A related tactic is to flood the internet with misinformation to thwart people's attempts to find pills. So fake abortion clinics, often dubbed crisis pregnancy centers, have long used misinformation to prevent people from obtaining abortion. They can go virtual too. In terms of criminal actions taken by states, there are 2 states with abortion laws that explicitly seek to punish the person who self-manages, South Carolina and Nevada. Other criminal provisions, however, have been used to criminally investigate or arrest people, according to the If-When House study that's been cited in a number of, that is kind of the go-to study that folks have been citing. 3/4 of the cases that we know about have been against the person procuring an abortion, and the other quarter against people helping them. These cases disproportionately target people of color and low-income people who are the majority of abortion seekers. We might expect to see states criminalize out-of-state providers if any part of a medication abortion process happens within a state's border, including consumption of the pills or expulsion of fetal matter. This concern has already caused some providers in states where abortion is legal to refuse services to out-of-state residents. The second drug, and this is, it just maybe bears a note, the second drug, misoprostol, is taken 24 to 48 hours after mifepristone, making the question of location important. Despite these strategies to stop mailed medication abortion, the proliferation of pills continues. So just last week, you might have seen the Guttmacher study that showed that states that border states with bans and states that have abortion permissive laws have seen an increase of abortion, and that increase nationwide has shown a jump, I think 8%, from previous nationwide abortion statistics. Aid Access reports that it has been shipping 7,000 pill packets a month since it began operating solely in the US for US customers or patients. So here I'll return to the shield laws I mentioned earlier because they respond in part to how people are gaining access to medication abortion and to threats of criminalization. So there are some common themes that underpin these shield laws. I think I'm good for time. Yep. First, shield laws seek to protect in-state providers' licenses and malpractice insurance rates. If a state tries to impose criminal or civil liability on a healthcare professional providing an abortion to someone from another state, that prosecution or lawsuit could be reported to the provider's licensing board, which typically has broad discretion in governing ethics and standards of conduct. Shield laws prohibit the state's medical board and in-state medical insurance companies from taking any adverse action against providers who face out-of-state legal consequences for assisting out-of-state abortion patients. This would not be blanket immunity for providers, but rather targeted protection applicable only to out-of-state investigations, disciplinary actions, lawsuits, or prosecutions arising from the services performed in compliance with the provider's home state law. Second, shield laws attempt to thwart investigations, both civil and criminal, of the care provided to patients. So on the criminal side, all states have enacted some form of the Uniform Act to secure the attendance of witnesses from without a state in criminal proceedings. It just rolls right off the tongue. It's very easy to say. And it calls for cooperations with witness summons in criminal cases. Even before witnesses are called, police departments usually work together across state lines via formal and informal cooperation agreements. States have exempted abortion providers and people who are seeking protected reproductive health care from interstate discovery, civil side, and interstate witness subpoena laws while prohibiting state and local law enforcement agencies from cooperating with other states' investigations. This only applies to abortions that are legal in the provider's state, and such exemption does not protect providers if traveling to an anti-abortion state. That travel would subject the provider to that state's law or judgment entered in that state's court. Nevertheless, shield laws try to prevent courts and the law enforcement agencies in the provider's home state from becoming a cooperating arm of another state's investigation apparatus. Third, shield policies exempt abortion providers from the state extradition requirements so long as the individual, consistent with Article 4 of the Constitution, is not fleeing from justice, covering the provider who never stepped foot in another state. Outside of constitutional requirements, some states' extradition laws permit or obligate the state to extradite accused criminals, even if they've never been in that other state and thus have not fled. Shield laws create an exemption for those requirements. Something that I'll just mention because I think it's an interesting aspect of these statutes in 17 states now. On the civil side, shield laws also create a cause of action against anyone who interferes with lawful provision of reproductive health care or support. But finally, and perhaps most relevant to our conversation today, 5 states of those 17 states are attempting to protect providers who are not only providing care to those traveling to their state, but also to providers mailing medication abortion pills out of state, even to states that ban abortion. telehealth policies and the standard of care typically define care as where the patient is located. And we can talk about what the policy rationale is for that definition. But Massachusetts, New York, Colorado, Washington, and California define protected reproductive health care as, quote, regardless of patient location, potentially shifting the location of care to where the provider is. Thus, the provider would not, according to their home state, be in violation of any other state's abortion or licensure law. It's that last aspect of these 5 states' shield laws that have encouraged, and to hear it reported, enabled providers in New York or California, mostly New York, to pack and ship pills to people anywhere in the United States on the back of this shield state language. These have not been tested in court. There has not been an interpretation to establish what regardless of patient location really means. And at the moment, it means the providers who are taking the risk to ship to banned states do not leave New York. They certainly don't come to Texas. So the legal battles happening now and on the horizon will shape the definition of abortion, potentially changing who is culpable for abortion crimes and inviting intrusions into health and personal privacy. Even as states try to police online activity and personal data, pills cannot be stopped. But they can. That's basically the thesis of our paper. Pills can't be stopped. But they can be pushed underground. They will deepen the public health and criminal justice consequences that new abortion bans have already catalyzed. So what remains for, I think, our discussion? Questions of information. Who has it? Who can use it? Questions of resources. Who can travel? Who has internet? Who has an interstate network? These concerns predated Dobbs. They have been foundational to abortion access all along. They are all the more salient now. Because if we continue to live in a country in which the privileged can obtain abortions without fear of punishment, but everyone else is at the mercy of the carceral state, the liberatory potential of abortion pills will never be fully realized. These are conversations that have to happen with the full recognition of the past movements for reproductive rights that too often ignored or sidelined the participation and perspectives of marginalized groups. Strategies responsive to Dobbs must center race, class, disability, sexual orientation, immigration status, and gender identity in the next phase of scholarship and advocacy. And we should expect and embrace disagreement as we look to long-term strategies to secure reproductive justice for everyone in this country. So at this moment of dynamism, I'll close by saying it's a time for bold, novel arguments to support pregnant people's right to seek an abortion and to address how the provision of abortion care has changed and will change. Litigation, indeed rights, can only take us so far, or may only take us so far. As underlined by this seminar and the course that Karen, Professor Engel teaches, reproductive justice demands thinking about the haves and have-nots, and having abortion-supportive strategies respond to why people seek abortion, and strategies that pursue a deeper systemic change. Thank you.
Well, thanks, Rachel, so much for that great talk. I always enjoy reading your pieces, the work that you write with David Cohen and Greer Donnelly. I would like to say I am not a lawyer. I am a researcher, and so I really appreciate Rachel's writings, Liz Sepper's writings, to help educate me about the law and the opportunities that we have for people advocating for reproductive rights and justice. I'm going to focus my remarks today on what we're seeing as we're talking to people who have been seeking abortion care in these banned environments and what this really means, the implications that it has for reproductive justice. As we know, the policy changes that we have seen over the last year have been seismic, as so many people have lost access to facility-based abortion care in their states. States that already had among the worst health and maternal health indicators in the country. And as healthcare providers, advocates, and researchers have looked at this fractured landscape, we have increasingly exalted the potential role of medication abortion to help bridge these chasms of care. We know that medication abortion will mitigate some of the very terrible consequences of the Dobbs decision. And so unlike the pre-Roe period, people now have a safe and effective way to end their pregnancies on their own in states that have banned abortion or where abortion care was otherwise unattainable. And the access to medication may just be a Google search away. There's already evidence, as Rachel indicated, and as I'll mention more in a moment, that use of medication abortion that is obtained through telehealth, online vendors, or through community activists has been blunting some of the impacts of the Dobbs decision. And because of medications abortion's safety profile, the sequela of unsafe abortion that has characterized the pre-Roe era will be far less common now. But for many of the reasons that Rachel and her colleagues lay out, and some that I'll describe here, medication abortion is not the golden ticket out of this policy crisis, and there are a lot of legal uncertainties that have emerged following the Dobbs decision. We'll continue to see many of the barriers to care that existed prior to Dobbs. They haven't been removed, and some will be exacerbated. And so we need to work towards solutions that will enhance equity in people's access to care. So a couple of points that I would just like to mention with respect to telemedicine, access to medication abortion, and information. We're still in the very early days in understanding how telemedicine might change the landscape. As Rachel mentioned, the SHIELD laws that have been passed are incredible policy achievements, but they haven't really been put to the test. So we don't know the extent to which they will protect patients and providers. We do know that having access to telemedicine for medication abortion is something that people in banned states are very interested in. From some of the research that we have conducted with people seeking facility-based abortion care in Texas in the weeks just before the final Dobbs decision came out, we found that 85% of the people that we talked to would be interested in using telemedicine for medication abortion if they could not get care at an abortion facility. This option to interact with a healthcare provider virtually was viewed far more favorably than obtaining pills through asynchronous online vendors like Aid Access or obtaining medications through pharmacies in Mexico. And we know that people are finding ways to kind of circumvent providers and use mail forwarding to get access to these medications if they're living in banned states. And we've also seen a huge increase, as Rachel mentioned, in the use of virtual clinics following the Dobbs decision. Research results from the Society of Family Planning's We Count initiative has shown that the number of monthly virtual health clinic visits for medication abortion has nearly doubled following the Dobbs decision compared to the months prior. About 7,500 virtual visits a month are taking place, and this does not include the 7,000 or so medication abortion pill packets that are being mailed by vendors like Aid Access. But we don't know who is actually getting access to these telehealth services and online medications. Aid Access collects very limited demographic information about the people who use their service. The limited research that is out there about the characteristics of people who are accessing care that has been reported by colleagues at the University of California at San Francisco indicate that virtual clinics are being used more often by people who identify as white and have higher levels of education, as Rachel indicated. And these are not the characteristics that describe the majority of people who have obtained facility-based abortion care in the months prior to Dobbs. And so this raises real questions about equity and access to care. Not only does this raise questions about who has access to internet, but who has access to a credit card? Who can actually obtain medications, have them safely mailed to their home, free from the intrusion of other people with whom they live? And we have certainly heard this from people that we have interviewed in states in the South, that they're afraid that they don't know what the packaging is going to say. They're stepfather always brings in the mail, and they're afraid that they will be discovered in their abortion decision. And so we need to uncover what some of these barriers are that are preventing some people getting access to telemedicine services in order to try to find solutions. Another point that I'd like to mention is about the information and misinformation that is out there. I think there's definitely growing awareness that medication abortion is a thing, that it is a way that one can end one's pregnancy. But dissemination of this information is not even, and some people have more access to better information than others. In a recent national survey, researchers at the University of California at San Francisco found that 2/3 of the people in their study had heard of medication abortion. And while this is really promising about people knowing what their potential options might be, they also found that familiarity with medication abortion was less common among women with lower levels of education, who were living on lower incomes and who identified as Black. So not everybody has the information that they might need to make these decisions. Moreover, in a survey that my colleagues and I conducted this spring among reproductive age women in Texas, we found somewhat lower awareness of medication abortion. Just over half of the 750 plus people that we surveyed had actually heard of medication abortion. Not only that, but only 40% of those who had heard of it didn't even think that the medications were safe or were unsure. And so this is really limiting people's ability to leverage these options for care. This provides opportunities for groups who are opposed to abortion to spread misinformation or disinformation about the medications through online platforms, as Rachel and her colleagues note in their paper. But this should be a surmountable challenge for many of those who are working to ensure access to the medications. I think a more difficult obstacle to overcome and helping people gain access to medication abortion that wasn't covered so much in the talk but is in the paper is abortion stigma. The movement of medication abortion outside of abortion facilities, which have been the target of protesters, and the use of medications early in pregnancy where the products of conception bear very little resemblance to the gruesome imagery that protesters often show outside of clinics, may help destigmatize abortion. But this is really focusing on stigma that is external and not the stigma that people face, the internalized abortion stigma that people have, or the interpersonal abortion stigma that people may encounter as they are considering disclosing their abortion or sharing their decisions with other people that they know. Moreover, being unable to get health care at a facility and feeling that your only option to end your pregnancy is to do so by purchasing pills online and having an abortion in your home may further reinforce people's feelings that they are doing something wrong and something that they should be ashamed of. Indeed, we have heard in some of our interviews with people seeking facility-based abortion care that they actually value the experience of sitting in a clinic with other people who are going through the same thing with them because it makes them feel that they are not alone. I want to focus the rest of my comments on the geography of abortion care. I find this to be such a really interesting component of the paper and something that we are seeing a lot surfacing in our research. And specifically the very chilling effects that these anti-abortion laws and efforts of people trying to put forward restrictions on abortion and medication abortion specifically are having on patients and providers. As comes up in the paper, the Dobbs decision has brought with it the specter of surveillance and the potential resurrection of zombie laws like the Comstock Act to prevent people from getting access to abortion pills. But what we're seeing with these threats of surveillance, that they were already real risks for people of color who were living on low incomes or who struggled with substance use disorders, whose pregnancy outcomes were criminalized before Dobbs. I think more concerning in some ways, although the legal threats are real or sometimes uncertain, I think some of the greater threats are the ways in which provider practices and patient behaviors are being chilled by the specter of these laws. By people out of an abundance of caution, changing the way that abortion care is being provided. We have certainly seen the chilling effects of abortion restrictions on the care that has been provided or withheld from people who are experiencing complicated pregnancies. But we're also seeing this in the way that medication abortion is being provided. Abortion facilities and providers, as Rachel mentioned, have been reluctant to offer or even deny medication abortion to patients who reside in states where abortion has been banned. There was a lot of kerfuffle around this in the early days after Dobbs, when some abortion facilities in Montana refused to provide medication abortion to patients who were traveling out of state. Also, that patients may be required to take the mifepristone and even the misoprostol in the state where abortion is legal before returning home because of clinicians' fears of the legal consequences. These protocols deny patients access to their preferred method of abortion and unnecessarily add to the time and cost that patients spend away from home and their other obligations. And just to highlight the real impacts that this has on reproductive justice and kind of the inversion of risk that we're seeing in this present moment, take, for example, a 25-year-old woman that we interviewed in one of our studies before the Dobbs decision, but after the implementation of Texas Senate Bill 8. This woman was going to college and wasn't working when she found out she was pregnant. And she was able to get an abortion, a medication abortion, in another state. But where she obtained care, the provider at the facility told her that you're supposed to take the abortion pills in our state. And the woman told us, that kind of got me thinking. I was like, was I supposed to stay in New Mexico and take these pills? I wasn't sure, but I couldn't. I didn't have the luxury to stay at a hotel or a motel. I just drove back and stayed at my brother's house. And so I think what this example highlights is that this requirement is either increasing a potential burden on patients, many of whom don't have the resources to stay overnight, but it also is instilling a new sense of risk for the person who is seeking care because they are now concerned that they are doing something that is wrong. This fear of consequences also extends across the entire spectrum of care as people are evaluating their options when they return home after obtaining a legal abortion in another state. We heard multiple accounts of people who considered visiting a healthcare provider after their abortion when they returned home to Texas, largely for reassurance because the medications are so safe. They just wanted to know that their abortion was complete. But they were worried what might happen if they disclosed that they had an abortion elsewhere and were suspected of having done something that was illegal. In one of the more distressing cases we heard, a woman that we interviewed did actually have a real need for follow-up care when she returned home to Texas, but was concerned, and she was concerned about the bleeding after her abortion. She told us that the clinic staff said that if I'm in extreme pain, I should go to the ER, but I didn't go to the ER because I was very, very scared of being judged. I'm not completely positive about the laws here, whether I was technically breaking a law, even though I went to another state to do it, but I did do something that's illegal here. And so rather than seeking the health care that she needed, she suffered at home. This chilling effect is also shaping the behavior of people who have found medication abortion online. In the interviews that we conducted with people who were searching for information about how to get an abortion after Senate Bill 8, but who did not obtain care at an out-of-state facility, we heard numerous accounts of people who were struggling with their decision about what to do about their pregnancy, prolonging their decision, potentially pushing them past the gestational duration at which mifepristone and misoprostol are most effective. One of these was a 32-year-old woman who was weighing the potential legal risk of ordering medication abortion online and the risk that that would have for her husband's military career against the real health risks of continuing a pregnancy that her physicians had indicated could result in paralysis if she continued, given her health history, or drive her back into severe postpartum depression, as she had with her prior 20-month-old son. Another woman we interviewed ultimately ordered medication abortion pills online, but decided not to take them because they took too long to arrive, and she felt that she would be too far along for them to be effective. Moreover, she was worried. If you take the pills and something goes wrong and you go to the hospital, they can arrest you now for that. You can literally go to jail for 2 years. You have to take it very seriously. And so we see that these chilling effects with misinformation about the law or uncertainty about how the law is going to be applied are permeating providers' healthcare decisions, increasing the potential risk that they are placing on patients or the worry that they're placing on patients, and that people who are considering abortion are also censoring their own behavior out of fear of legal uncertainty. So despite the many challenges that are ahead, I think there are some reasons to remain hopeful. We have learned a lot and can continue to learn more by talking to people who need abortion care about what they need to help drive these solutions, to help them get access to the resources that they need. We can learn how to better communicate and message around the options that are available. In some of the interviews that we have done, people are thinking very differently about telemedicine for medication abortion versus ordering medication abortion online through platforms like Aid Access, even though the medications that they're receiving are very much the same effectiveness. But they see these as being very different. So is there a way to communicate about that better? I think there are also ways that we can think about how to address misinformation about the medication and options for care. And right now, still, sharing information remains legal. I think it's also important to note that the general public overall is not in favor of criminalizing people for ending their own pregnancies. We have seen this with the public outpouring of support for a woman in South Texas and rage over her prosecution or arrest a year and a half ago, but we've also seen this in our research as well. In the survey that I mentioned earlier of reproductive age women in Texas, we found that just a small fraction of people thought that women who self-manage their abortion should be prosecuted for doing so. And although even any fraction is still concerning, it clearly indicates that there's not widespread support for this kind of legal interference in people's reproductive decision-making, and I think that we can take heart in that. And I think we can also remain hopeful by looking at the lessons that are provided by history and from other contexts. When activists and other advocates get creative and work tirelessly against patriarchal states with strong religious influences to try to overturn legal restrictions on abortion and make it a safe and legal option for care. Thank you.
Thank you, Carrie. I think that was fantastic, and I'd love to open it up to questions, and I will just, I guess, a couple of things that I think are really worth emphasizing, which is this question of information and who has access to information is a complicated, much more complicated than just putting up a website and saying, feel free, please read. And so I think about that a lot as well. And, your work has been so vital to this because, well before Dobbs and before SB 8, it was clear that in surveys, many people who were seeking to end pregnancies outside of the medical establishment were not using pills. They were resorting to, they were going to other methods because they didn't know pills existed. So, one study I think that was in 2019 showed that barely half of people who were terminating pregnancies were doing so with pills or understood that they existed. And I think that's startling. That the thing, of course, that I thought of in the 40% that don't think that pills are safe is both the on the ground reality of what people understand about medication abortion, and frankly, people's well-founded fear of prescription medicine and of the medical establishment, especially people who do not have privilege, who are not wealthier, white, and the like. But this also, from a lawyer's perspective, what truly is so corrosive about the fight in the Fifth Circuit and in the district court about mifepristone safety, that we can, I've done way too much reading on the records that the Judge Kaczmarek and the two panels relied on, and it just, I'm someone who thinks that evidence is political, that facts are political, and they can be used towards political ends, but I'm having a really tough time trying to figure out how to talk about decisions that just will ignore decades of safety information, and how do we engage in that conversation in light of what we know about the misinformation writ large about how medication abortion works and about its safety. And then the last thing I'd say to your fantastic comments, I think that the question of shame and stigma is really tough. Any marriage has its disagreements. And it's not that Greer, David, and I agree entirely about everything that's in the paper. And I think this is one point where we've come at the issue of stigma and shame with somewhat different takes on what the takeaway and what the payoff of talking about medication abortion is shame reduction, as stigma reduction. And I really love the point that you make, which is the unintended consequence that having a personal at-home process, especially when you haven't had any contact with any kind of healthcare provider or the like, or intake or form or something, can deepen shame. And it presses the question for me of the difference between shame and stigma. Is something that we were chatting about. I want also just in conclusion, second, that those of you who have not read Liz Sepper's work in the area, please do. So is that, yeah.
Great.